Welcome to Globe Watch with me, Charles Ebuni. The Organization for the Harmonization of Business Law in Africa, better known by their French acronym OHADA, celebrates 20 years of existence with 17 African countries exclusively as members, although the organizational chart calls for an open door policy. The Organization for the Harmonization of Business Law in Africa, modeled from a French legal sense, is one of the most important legal business tools on the continent, facilitating businesses and encouraging commercial transactions across the continent, especially amongst some French-speaking countries in Africa. Since 1993, OHADA has struggled to provide judicial security to promote business transactions in Africa. 20 years on, can Africa and the rest of the world count on OHADA? The chair of Comparative Law in Africa at the South African University of Cape Town, Professor Salvatore MANCUSO. Welcome to Globe Watch.
Thank you.
The Permanent Secretary of OHADA, Dorothée Cozy-Souza, says, quote, and the translation is mine, "In 20 years, the Organization for the Harmonization of Business Law in Africa has imposed itself globally," end of quote. How credible is that statement?
Well, in my view, it's credible because the OHADA has reached a considerable success. If you speak in the legal environment around the world, and not only in Africa, about OHADA, every people knows what you're talking about. I have been going around Africa for more than 20 years. And I can tell you that at the beginning, no one was knowing about OHADA. Today, everyone knows about OHADA, I have to say. OHADA, the success of OHADA, in my view, has been witnessed by the fact that many international organizations support OHADA.
Such as?
Such as the African Development Bank, such as the World Bank, the International Finance Corporation, the European Union. They all have put not only, let's say, logistical support, but also financial support to improve OHADA and to facilitate its divulgation into the African countries.
What makes them to be attracted to OHADA? What are the special qualities of OHADA that makes them to love OHADA? Because I'm sure that there are other legal systems across the continent, but you say that this is something which is backed by so many organizations, including the UN system, the United Nations Development Program. So how qualitative is the OHADA business law?
The business law, the quality of the business law is, generally speaking, a good law, I have to say. A law of good quality, well drafted, linked to the French, as you said before, presenting the OHADA, linked to the French model. The fact that makes OHADA attractive is the fact that basically with the same law, you have presently 17 countries are members of OHADA, you have 17 markets open. And the fact that gives not only legal but also judicial security, obviously, is a very important step forward in the development of the continent.
You said in the development of the continent, we will be talking about the contribution of OHADA in the development of Africa, especially the business environment in a moment. But just tell me, where does OHADA come from?
OHADA comes from an idea that was developed by the late Judge Kebambaye from Senegal to cope with the problem of legal and judicial security in the continent. We know the fact that in the continent, in many countries, the laws were, especially in the area of business law, were inherited by the former colonial powers, and the law were not updated to face with the global market, with the new needs of the business environment. On the other side, there was the need to give to the investor judicial security. this means to have a possibility of predictable application of the law. And OHADA has been conceived exactly to cope with these problems. It has been, as you said, signed in Port Louis in Mauritius in 1993, and the treaty has been reviewed in 2008 in Quebec City in Canada, exactly to update the OHADA after 15 years, to update the OHADA to the developments of the business environment. This is one of the features of OHADA. OHADA is not static, it tends to be, the intention is to have it dynamic, to adapt it.
You said it is a dynamic law. And my major worry, it is true, top government officials from the 17 countries, development partners, and other associates of OHADA were part of celebrations in Yaoundé in the course of the week. Yes. You said it is a dynamic law, but you know at the same time that the big markets in Africa, South Africa, Nigeria, Uganda, and others are not part of the OHADA system. What is OHADA losing by not having the big markets in Africa part of their system?
I have to say that the question should be more if these countries would be member of OHADA. The answer is definitely not in the short term. This is because there is presently a clear understanding that OHADA is something very close and very attached to the civil law model and to especially to the French law.
Absolutely.
This is something that I have to say is not totally true. We can say that most of the laws are very, very, very close to the French law. But there are, if we look carefully at OHADA, we see that there are several features that are similar to what the common law system says. Just to give you an example, the Common Court of Justice and Arbitration is the court of last instance for every matter involving the application of the OHADA business law. Well, the Common Court of Justice and Arbitration, when is resorted for judging a case in last instance, as a judge of last instance, it decides not only on the interpretation of the laws, but it decides also on the merits of the case. So the case is not sent back to the national courts to be adjudicated again. And this is something that is absolutely new for the civil law model. In everywhere, the Supreme Courts are judges that interpret the law, and if the interpretation is not correct, the interpretation given by the judges is not correct, they send back the case to the judge to have it re-adjudicated following the interpretation that has been given by the Supreme Court.
Most countries where OHADA is practiced, including Cameroon, where you have a traditionally English-speaking part of it, complain that all OHADA laws are in French, and they find it's very difficult to apply the OHADA law when it comes to businesses, especially in the northwest and the southwest part of the country. And so magistrates who are not trained in the OHADA system find it so difficult to exploit the law and even to understand it. They call it a very complex something from France. Now, how do you try to make OHADA to be part of a linguistic legal tender in those areas?
I think that this is one of the limits of OHADA, the fact that everything is conceived and and most of the activities are done in French. But at the same time, I believe that Cameroon, being the only bilingual and bijural country, not only within OHADA, but also in Africa, I think that Cameroon can contribute a lot to cope with this problem, to overtake this problem.
How do you do that? By sending English-speaking magistrates to the regional training school, which is based in Benin? Is that a solution?
It's not a solution.
Because those who are sent there are mostly French magistrates, so you are not solving the problem.
No, I know that you are not solving the problem. But for example, Cameroon has people who speak English perfectly, and they contribute to have English versions of the laws ready for being understood by the English part of the population. Obviously, the judges who are English speaking can also have training, and they can also contribute into the school, in the training school in Benin, to have training courses for English speaking people, I mean legal professionals. This is what the training school is also aiming to do, not only in English, but we have to remember that Ohada has one Portuguese speaking country and one Spanish speaking country.
Okay.
And they also have the same problem, and they also are trying to, at the school, they are also trying to solve this problem, providing training for English-speaking, Portuguese-speaking, Spanish-speaking
Okay,
countries.
let's go specific.
Yes.
My name is Charles Ebune.
Yes.
And I want to open a sugar public limited company in an Ohada country.
Yes.
What is the procedure? Since you say it is a simplified one and a good one.
The procedure is according to the kind of business you want to open, and to the type of business you choose among those that
I've already
are
given an
promoted.
example.
Yes,
A sugar,
company.
a public limited
You
company.
can. The question is, I mean, you cannot have one timing to set up a company that is valid for all countries.
How does it take to start up a company in an Ohada country? How long?
To start up, as I'm saying, you cannot have.
I'm not
this
talking
country.
about a small and medium-sized enterprises.
Yes.
That is not what I'm talking about. I'm
Yes.
talking about a public limited company. How
limited
long can it take to operate?
Exactly. And what I'm saying is exactly this. You cannot have an answer that is valid for 17 countries.
Just give an
Because
example in one country. That is
Ohada,
where I am interested.
Yes. Ohada, the concept is this one. Ohada is giving you the tools. Then the member countries have to apply the tools. And it depends not only from Ohada law, but also from the administrative procedures that are outside of the Ohada law.
Okay. Which are those
just to give an
tools? Yes.
just to give an example,
Yeah.
if you have to put let's say a nail in your wall, you go in the hardware shop to buy the hammer, and you cannot ask to the owner of the hardware shop how many hits I have to give to the nails to put it into the wall, because it depends on your strength, it depends on what you have to put, it depends on the size of the nail, on the wall, how hard is the wall, how soft is the wall. There are a lot of other things that are outside of the control of Ohada, so you cannot give a precise answer on this.
Okay. There has been so much chanting on the achievements of Ohada 20 years on. What has Ohada done in particular to encourage economic growth and the creation of enterprises in Africa? Because if I look, the celebration theme is Ohada at the service of the economy and the enterprise. What has Ohada concretely achieved in that area 20 years on?
Ohada is, I can say, Ohada has given a new concept of approaching business law in Africa that is exactly an harmonized approach to business law. And this is important because today, in the global market, your competitors are not anymore locally situated. You have competitors everywhere in the world. So you have to make economies in terms of putting your products into the market at the lowest possible price to be competitive. So obviously you have direct economies, but also indirect economies. And one of the indirect economies is represented exactly by the access into the market. If you want to enter into the Cameroonian market, if you want to enter into DRC market and so on, you have to understand the law. You have to understand how you can enter into that market, which are the legal requirements. Today, with Ohada, if you understand Ohada law, if you can get the tools to use Ohada law, you have 17 markets open.
Okay, you said you have 17 markets open, but my major worry is that a in legal sciences, there is what they call the lege lata and the lege ferenda. That is the letter of the law and the spirit of the law.
Yes.
When I look at the spirit of the law of Ohada is to facilitate and reduce economic bureaucracies to make sure that business moves faster and to sustain growth and ensure judicial security. But you know that each time economists produce the doing business report around the world, Ohada countries are ranked some of the worst areas of doing business in the world. Why?
I have to say that at the same time, if you make a comparative analysis of the doing business reports of the World Bank, you see that Ohada has given the possibility to the member countries to improve in the ranking. Obviously, there are other factors that contribute to this situation. Political stability, for example, investments. There are a lot of things that are also outside of the Ohada control that are considered into the doing business reports. Because obviously, if you have a good legal system, but then you don't have a judicial system that is capable to put in place that good legal system you have, then obviously you have difficulties there. So the important thing is that Ohada is definitely improving the business situation, the business environment in the countries, and is also helping investments. Just to give an example, I have been speaking with a Nigerian judge who was previously a company lawyer, and when he was working into his company, he had to do business in Côte d'Ivoire, in Benin, in Togo, and whenever he was going around and asked what I have to do for this and what I have to do for that, the answer was immediately Ohada law, Ohada law, Ohada law. And he started to interrogate himself, what is this Ohada law? It's interesting because everywhere I go, I find it. So this is important. We make business with countries which surround us, and they all have this Ohada law. Even if we are not a member, and we go back to the question that you made before, even if we are not a member, we must know it, because it's something we have to face, because we do business with them.
Mercantilistic law, or simply put, commercial law or business law, is an issue of protecting creditors and investors at the same time. What judicial security does Ohada law give to creditors and investors at the same time?
Well, judicial security...
Because if you talk to top business magnates, even those from France, where Ohada idea was coming from, would tell you that it is preferable to do business in areas which are not even at peace and are out of the Ohada community, where most of them are relatively peaceful. So what is Ohada doing in that business?
In terms of protecting investors and creditors, I have to say that Ohada, in terms of legal framework, Ohada has one of the uniform acts that exactly deals with credit collection, and another one that deals with securities. So the framework is there, and there is also a specific uniform act on bankruptcy. And one important thing that I have to mention in this respect, in terms of judicial security for the creditors, is the fact that Ohada is one of the first systems providing a transnational bankruptcy procedure. So if you have one company that has assets in different Ohada countries, you can open only one bankruptcy procedure to cover all the assets in the different Ohada countries. And this is a very important guarantee for the creditors. Okay. The other thing is that in terms of judicial security, I have to say the Common Court of Justice and Arbitration secures the common interpretation of the law. I mean, wherever you go into the 17 countries, the law is applied in the same way, because there is only one court of last instance that is delegated to apply and interpret the law for the 17 countries.
Okay, what are the innovations that Ohada is providing to member countries? I hear that you want to introduce e-commerce. What are the other innovations you want to introduce, and How challenging is the Ohada environment today? What are the challenges that the association is facing?
In terms of innovation, Ohada, as I said, is trying to be dynamic. So they are thinking to enlarge the law in covering other aspects of business law that are presently not covered, like leasing, factoring, and similar kind
Cash and carry.
similar kind of commercial contracts. One of the big challenges that Ohada has is, I would say, Ohada is at a crossroad presently, and it's starting to interrogate itself on which direction it has to go, in which sense, because one important thing is to determine who are the addressees of Ohada law. Is a law only for the investors, or is a law for all the African population? This is a big question, because if you want, in my opinion, if you want to have a law that is not only for the investors who come from abroad, but also for the daily life of the people, you must render it more approachable, closer to the African people. And we know that in Africa, almost 70% of the gross product is made by the informal commerce, the informal activities.
So how?
And Ohada is exactly going in that direction. It has put in place several mechanisms to try to bring the informal sector within the formal sector. An example is the creation of what is called entrepreneur. That is something extremely new, and it's a small entrepreneur that would...
One question before we separate. When it comes to litigations, when somebody has a commercial problem in the Ohada system, how is that solved?
There are two choices. One is to go to the courts, to the normal courts, knowing that your case at the end will be adjudicated by the Common Court of Justice.
Is the procedure simple? I'm interested in knowing whether the procedures are fast, because you know justice delayed is justice denied.
Exactly. But that's exactly important. The Common Court of Justice and Arbitration is extremely fast. And the important thing is, as I said before, that the judgment is not sent back to the national courts, but is decided by the court, definitely, whoever is the party that has reason. But on the other side, I have to say, Ohada is very committed in promoting arbitration as an alternative dispute resolution mechanism for commercial disputes.
Good. You are the chair of Comparative Law in Africa at the South African University of Cape Town. If you are to do a final comparative analysis of Ohada and other legal tools for doing business, will you coach somebody to go in for it?
Yes, I have to say that Ohada is unique in terms of characteristics and peculiarities. Why? Because if you look at other experiences of harmonization of laws, those experiences you have in Africa and outside of the continent are experiences that are linked to some economic integration. Or let's say, even better, regional organization aiming at economic integration. Ohada is not this. Ohada is a pure tool for legal harmonization. It does not have any direct link to any organization aiming at economic integration. It was to promote business and development in the country, but is not attached to anyone, to any organization like the other existing in the continent.
I am afraid we have to end there. Professor Salvatore MANCUSO, thanks very much for accepting to be guest on our program today.
Thanks. It has been a pleasure.
Okay.